Hi, how are you? Thanks for joining me here today. This video is about the Lugano Convention and how it can affect you and your family. So if you think that the Lugano Convention isn't important, or that it only refers to big business and doesn't really concern the little people, then I'm afraid I have some very disappointing news. Each and every single person living, working, doing any business at all in the UK is going to know somebody that will be affected by the Lugano change. So let's get to it. I will start with a simple question. Did you realize that if you travel to any place in Europe and meet with an accident, whether your fault or not, or maybe take a claim against a holiday company for whatever reason, that it's going to be a hell of a lot more problematic than it was before January the 1st? No? Well, it is. Now, hopefully, after hearing from a number of experts in the field, which we'll listen to later on, these guys are real guys, real McCoys in international arbitration, you'll have a better understanding about what has changed, and it'll give you a practical view on recent events that have now begun to manifest themselves in day-to-day business in the City of London in particular. They'll explain why their own clients are now concerned and want to change the way that things have been done in the past. And why? Well, it's quite simple, because they're very afraid of what the future holds, and with good reason, as even some lawyers are afraid of being arrested. So don't worry, we'll get to that. So, how about this one? Did you know that 3,200 lawyers, mostly from the UK, have applied to the Law Society in Ireland for a license to practice law? That's 10 times more than the normal figure pre-Brexit. So notepads at the ready. So what has happened? Well, the UK applied to accede, which basically means join, to join the Lugano Convention. That convention was an agreement between the EU, Iceland, Switzerland, and Norway. Now, to join the Lugano Club requires unanimous support from all members. Now, I've already spoken with a number of uninformed lawyers who claim that the courts in London, you don't need to worry about anything because they've got it all under control and you can rely on the Hague Convention. Okay, this is rubbish and provides an extremely dangerous sense of safety when it comes to the law. Your clients could be standing in quicksand. You could be standing in quicksand if any lawyer says that to you. It's simply not the case. Now, for an example, imagine you designed a new website and somebody in Lapland or Luxembourg or Le Havre copied that website. Before January the 1st, you could have run down to your local court and applied, and almost certainly would have got an interlocutory motion, or what you might know as an injunction. And that would stop the other person from operating that site. And you could have gotten that within hours. That protection was there within hours. That protection is now gone. There is no way you're going to get that protection now. The damage, you'll be able to do it in their court, but that's a year down the road and the damage is already done. So let's look at a 2-minute intro from a guy called Stuart Dutson. This is a Dr. Stuart Dutson, very, very experienced guy in arbitration.
Updated. But I was fortunate enough to enforce continental judgments, so judgments from continental Europe in the UK under the Lugano Convention, and to enforce UK judgments in EFTA states, principally Switzerland, under Lugano. And my observation was that as Jonathan says, the Lugano Convention was very prescriptive, but within those prescriptions, it provided a very predictable, quick, and easy means of enforcing the judgments of EFTA states, so Iceland, Norway, Switzerland, in the UK. And I've seen it time and time again that they were enforced with relevant ease under that convention. Now, conversely, I also was enforcing on a number of occasions UK English judgments, principally in EFTA states. And again, that was principally in Iceland in relation to the financial crisis, and also Switzerland because of its general nature of its banking practice. And I found in those countries, it was a little bit more difficult to enforce a judgment, an English judgment under Lugano than it was the other way around. So principally, it only covers exclusive jurisdiction agreements. It does not cover non-exclusive jurisdiction agreements. So if the option is given of suing in English courts or elsewhere, it will not apply. It will not apply to asymmetric jurisdiction clauses. And we've all seen, particularly in contracts with banks, one party is given the benefit of the jurisdiction clause, so it can choose to sue elsewhere if it wants to, but the other counterparty has no choice, it must sue in the courts of England, say.
So, what's happened since this webinar with Lugano? This webinar is a couple of months old. The EU Commission told the UK basically to take a hike. And this is a major problem, particularly in the real enforcement of court findings, such as a divorce, breaches of fiduciary duty, breaches of contract, especially in financial services, especially that industry. To understand the importance of such deals, one only has to look at the Canada trade deal with the EU. Now, these negotiations weren't rushed. They were carefully negotiated with both sides in a position to walk away if the negotiations didn't meet with their trading requirements. Now, this is something obviously the UK forgot in the trade agreement with the EU, but there's little point in going over spilt milk, and we did a video on that called the numpty frost, if you'd like to take a look at it. But what the experienced negotiators in the Canada deal realised, which by the way was significantly smaller than the UK deal, is that inevitably there will be issues. There's bound to be. Both sides recognise this and set up legal mechanisms to deal with it, because they want to avoid lengthy court cases as well that could be challenged on a constitutional basis in any of the EU member states. And by the way, to point out, right now in Ireland, there is a constitutional challenge going on the Canada trade deal. Okay, but anyway, the decisions and all the investment protection provisions in that agreement will apply once it's been ratified by all the lawmakers in the EU states. Again, let me remind you, this was foreseen. They knew that was going to happen and they prepared for it. So, enough of me, let's get back to the real experts. We're going to hear now from Philippa Charles. Now, I've edited the video a bit because much of the submissions they're speaking about are more technical aspects of the law, but I have included a link to the full video in the description below if you want to check it out.
I think what's perhaps more interesting and more of a challenge is the kind of the perception of the business community about the situation in London now, and how attractive London now is for them as a venue for their dispute resolution processes. And it just seems to me that, you know, uncertainty, as we have now in relation to the question of whether there'll be an accession to Lugano, is inevitably damaging to London's standing within the user community, because there's a lack of certainty about what the outcomes are going to look like or how enforceable an outcome is going to be. But I think if we're looking at London as a dispute resolution hub in the wider context, clearly, you know, the sooner we can get some certainty about what is and is not going to be possible going forward is going to be really important.
And right there, you can hear clearly her concerns. But were these echoed by her other panelists? Yes, yes, and yes. Here's Stuart again. Now, guys, you could be forgiven for thinking that the EU member states do not need English law, as they have their own, and this is a legitimate argument. However, most, if not all, international law, trade or otherwise, is based around English law. Okay, all of it. But that does not mean that English law cannot be practiced outside of the UK. In fact, it is often practiced outside the UK and almost always in the financial services industry. And therefore, think about this one. As the Republic of Ireland also has centuries of experience in English law, because it's the same law, wouldn't that go a long way to explaining why those 3,200 have applied to the Law Society in Ireland to practice?
So there's considerable uncertainty, and the way in which countries apply their law is also likely to change as they come to grips with the change of status of UK lawyers in the EU. So all one can say is be careful, make sure that the arbitration is being conducted in the country without without restrictions, rather than the country which does have restrictions. It would be very sad to see lawyers being arrested at the airport and being let off after a tip-off from the other side saying you're not allowed to come here and provide services for your client. This arbitration is going to happen tomorrow.
Now, let's take a listen to the practical implications of Brexit and the UK and its failure to join the Lugano Club. Now, while watching this expert, it needs to be borne in mind that the UK service industry is by far the biggest single contributor to the UK's economy. The biggest, and it's the most affected. So let's hear what they think, shall we?
And I think we were talking as we came on the call, Philippa, Jonathan and I, about what we're seeing our clients doing. And I noted that at my firm, we act for a number of on a number of financial transactions where we see European institutions on the other side, and where in the past they would have said we're very happy. In fact, we want English law, and they would have been prepared to accept London courts for dispute resolution. They're now saying no. We see we have to go for English law, and they kind of see that they say we're stuck with it because it's the only law that works for this transaction. But we're not prepared to accept English courts anymore because you've left the club.
And so yet again, we can hear clearly that things have already begun to change. And since I participated in that discussion a number of weeks ago, it has basically been confirmed that the Lugano Convention, for the sake of the UK, it's off the table. And that has happened despite the challenges of COVID and the need to negotiate and communicate remotely. The EU Commission don't want to know anything about it. They're not even making a recommendation. Now, the financial services industry in particular has already changed their modus operandi, and as you will hear shortly, the banks do not wish to be exposed. If litigation was to occur and their clients can avoid the legal costs of London, which are the highest in Europe, they're going to do it. No question about it. And now, absolutely, they're going to have the option of hearing the cases outside London, which means the lawyers are going to be in trouble. And there's a lot of other industries involved around contracts. Huge banks, insurance companies, reassurance companies, stockbrokers, fund managers, asset managers, they all require legals. And if you draw up a contract in the UK and you have it written on the contract, as has always been the history of those contracts, is you can hear it in London. Well, no, you can hear it in London, but enforcing it, you already heard from Stuart that even when the UK was a member of the Lugano Convention, if a case was heard in London, it was more difficult to get the cooperation of some of the European countries to settle that dispute, to pay the money. Now, it's going to be impossible. In summary, I think it's fair to say that nobody in their right mind would want to adopt a legal position that leaves them exposed in the case of litigation or arbitration. Now both sides of the contract are very much aware that the execution of any judgment delivered in London but against an EU party is fraught with dangers, and vice versa. So the London's business is mostly export. I mean, 48% of the business that London does is in Europe. Those contracts are going to switch to Europe. There's no question, they have to, because otherwise those companies will not get insurance cover from their banks are going to insist that they're covered, that those cases can be heard in their local territory and can be enforced. I want to thank you for tuning in, and I look forward to meeting you in the next video. Thank you.